أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله والصلاة والسلام على رسول الله وعلى آله وبارك وسلم. Assalamu alaikum, dear students. I welcome you all once again to another session of online video lecture series for the subject business law. This is our lecture number 7, and inshallah we'll begin chapter number 4 today. And chapter number 4 is about important essentials of valid contract. This chapter consists of 3 lectures, and inshallah in these 3 lectures will be delivered in 2 video lectures, video lecture number 7 and video lecture number 8. So let's begin with our first lecture of this chapter, which is the consideration. Consideration is one of the most important essentials of a valid contract. In our previous lecture we had discussion on offer and acceptance. That was the first essential, and this consideration is the second essential of the valid contract. So what consideration? We had discussion on this in the first chapter on preliminary basis. Now today inshallah we'll have discussion on consideration in great details. So what is consideration? Consideration is basically something which is of some value in the eye of law, something of value, something of economic value in the eye of law. So the value is not specified. The value could be less, the value could be more, but there should be something of value, of economic value, and that value should be in the eye of law, and that valuable thing should be exchanged as a result of the performance of the contract. So a contract must have a consideration, and that consideration should be lawful. Unlawful or illegal consideration are not the essentials of the valid contract. For a valid contract, the consideration must be present, and the consideration should be lawful. And what is consideration? Something of economic value in the eye of law. Something given or obtained is also called consideration, and that something given or obtained by the parties, or what exchanges between the parties, that should be lawful, and that is called consideration. So examples of considerations are here. For example, Ahmad agrees to sell his house for 100,000 Afghani to Bilal. For Ahmad, consideration is 100,000 Afghani. For Bilal, consideration is house. So house is has economic value, and its consideration for one party. Money has economic value, and it is consideration for the other party. So this economic value is exchanged between the parties. This is called consideration, and it should be lawful. Lawful means that this 100,000 Afghani should be the property of Bilal, and these notes should not be fake, and house should be the property of Ahmad, and there should be no claims of other parties in this house. So then house for Bilal and money for Ahmad are lawful considerations. There is another example. Ahmad promises to paint a picture for Bilal, and Bilal promises to teach him for 1 month. So both of the things in this party, in this example, for both parties there is a consideration. Painting a picture has economic value for one party, and teaching has economic value for other party. So one party is teaching him, the other party, for 1 month, and against that education that he receives from another party, he gives him a value which is painting a picture. So for one party Painted picture has economic value and is a lawful consideration. For other party, getting education has economic value and is consideration for him, so it's also lawful consideration, and there is a contract between them, and this contract is valid contract. Now let's talk about the essentials of a valid consideration. Means what things should be present in a valid consideration. A consideration is valid if it consists of all these six considerations. Number one, desire of promiser. Number two, promisee or other person. Number three, act, abstinence or promise. Number four, past, present or future, not necessarily adequate. And number six is real and competent. The first essential in the consideration is that it should be according to the desire of promiser. The consideration should be according to the desire of promiser. Means whatever is the desire of one party should be given by the other party, and whatever is the desire of other party should be given by the first party. Means consideration is something that is wanted by that is the desire of the parties, so both parties should benefit in a way, each other in a way that is the benefit from one party should be the desire of the other party, and the benefit from this party should be the desire of the second party. So that's the first essential. Later on we will discuss them one by one in details. The consideration could be of a promisee or could be of another person, right? The consideration could benefit a promisee. Promisee is someone to whom the promise is made, means the second party in a contract, and third person, other person could also benefit from the consideration, even though he was not the part of the contract. But if the consideration of the contract is for the sole benefit of third party, so the consideration may move from the promisee to other person or third person as well. Consideration can be an action, can be abstinence or not doing an action, and it could be a promise. Consideration could be past, it could be present, it could be future, right? The value of the consideration is not required to be adequate. For example, if one party, both of the parties with free consent agrees to benefit each other, but the value of the benefit that they will exchange, it's not necessarily to be adequate or to be equal. One party can benefit more, other party can benefit less, but both parties should agree freely with having free consent. The consideration should be real and it should be competent. Unreal and incompetent considerations are not accepted by the law. Now let's talk about these in details. Desire of promiser. For a valid consideration, the act which forms the consideration must be done at the desire of promiser, right? For example, Ahmad saves B's house from fire. B did not ask for help. A cannot demand payment for his service because his act was voluntary, right? He acted voluntarily. So the consideration should always be at the desire of promiser. Means the parties who enter into a contract, both of them should have a desire for a benefit. If I benefit another party, that benefit should be the desire of that party. If that party benefits me, that benefit should be desire of me. So there should be a mutual desire for the consideration for that benefit. Number two is promisee or other person. A consideration may move from promisee or any other person. For example, Ahmad gifted to her daughter Rima on condition that she would pay amount annually to Ahmad's brother C. Rima promised to C. Later, Rima refused to pay. Then C sued, held that C could sue or Rima to recover the amount as the consideration moved from Ahmad to C. Here we can see that there was a contract between Ahmad and, say, A and R. A is mother, R is the daughter. So mother promised or gifted her daughter a property, right, with a condition that her daughter will pay her brother, mother's brother, like her uncle, a certain amount of money on annual basis, right? So at the time of contract, daughter promised to her mother that she will pay a certain amount of money to her uncle annually, but later on the daughter refused to her uncle to pay. Uncle had to sue her, and the court decided that she had to pay annually because the consideration of the mother has moved to the uncle, right? I mean, the contract was made for the sole benefit of the uncle. Like, there was no benefit to the mother by gifting her property to the daughter, but the benefit was to her uncle, and her uncle's benefit and her brother's benefit was his benefit, right? Mother's benefit was basically the benefit of his brother, who is the uncle of her daughter, right? So that's why we studied that a consideration may move from the promisee to other person. If the contract is made for the sole profit of that other person, then the consideration moves from the promisee to other person, which means that the promiser has to perform his contract, has to fulfill his promise to that other person, right? Okay, next is abstinence and promise. The third essential of a valid contract is act, abstinence, or promise. It means that a consideration could be an act, which is doing of something, and in this sense consideration is in positive form. For example, P agrees to construct A's house for $10,000. A's promise to pay $10,000 is consideration for P's promise of constructing the house, right? So there is an action, construction of a house, an action from P, which is a consideration for A, and A's payment to P, that 100,000, is the consideration for P. Abstinence means refraining or stop doing something. In this sense, consideration is negative. For example, Ahmad promises not to sue B or Bilal if Bilal pays him additional $100. There is an abstinence or stop doing something, which is not suing Bilal. So for Ahmad, $100 is consideration, but for Bilal, not doing an action by Ahmad is consideration, right? So this is called negative consideration. Promise. For a valid consideration, there must be promise from both sides. It means that there must be promise by one party against the promise of other party, and the example is here. This is the best example for this. Like P has a promise for construction of house, and A has a promise to pay him $1,000, right? So this is called promise. So we know that a consideration can be an action, can be not doing an action, and can be a promise. For action, we had an example here. This is example. You see, painting a picture from Ahmad and teaching for 1 month from Bilal. So from both sides there are actions. The action of one party is the consideration of other party, and the action of other party is the consideration of first party. So this is the example for the promise, and that was the example for action, and here is an example for the abstinence. Let's continue with the fourth consideration. The fourth essential of the consideration is past, present, or future. It means that consideration is an action which has been done, or is in progress, or is promised to be done in the future. In both cases, the consideration is valid. For example, when consideration is given before the formation of an agreement, it's called past consideration, right? But in this case, it's not valid. But if promise is made to compensate a person who has rendered some services, the past consideration is valid. For example, first the service has been delivered, right? And then now there is a demand for the reimbursement against that service. In this case, consideration is invalid. But if there was a promise to deliver a service, the service is delivered and the payment is paid now, then the service which was delivered is the past consideration, right? So in this case, the consideration is valid then. For example, Ahmad teaches Bilal at his request in January, and in February Bilal promises to pay $100 for his service. The service of Ahmad is past consideration, right? For example, and there is a teacher, Ahmad, he teaches Bilal in January, then Bilal in February promises that he will pay him $100 for his services in January. So this is called a past consideration. In case like this is valid. What is the invalid case of this? The invalid case would be Ahmad teaches Bilal without and there is no promise from Bilal's side for the payment, right? And later on Ahmad starts demanding $100 from Bilal. In this case, this would be a past consideration but invalid case, because there is no promise from Bilal's side for the payment, right? So we have to be careful in such situations. While entering into a contract, we have to make sure that the consideration is valid. Otherwise, when the consideration is invalid, the contracts become invalid, and invalid contracts are not enforceable by law. When contract is not enforceable by law, you cannot get what you deserve and what's your right. Law cannot help you in that. Now the fifth essential of a valid consideration here is not necessarily adequate. It is not necessary that the consideration is equal in value to the promise. Means it totally depends on the free consent of the parties. If one party has a free consent to benefit more than the other party's benefit, law has no question here. For example, Ahmad sells his 100,000 worth of car to Bilal at $10,000. So on one side the consideration is of value of 100,000. On the second side, the consideration is worth of $10,000. So there is it's not necessary that both parties should benefit themselves equally, but it depends on their free consent. If they have free consent to benefit each other on agreed value, law has no question on that. Real and competent. It's necessary that the consideration is real and competent. A consideration is not considered valid if it's physically impossible, if it is illegal, if it is uncertain or untrue. Here, real and competent mean that something should physically exist, and the possibility of delivering that, there is a possibility of the delivery of that, and it should not be illegal. Incompetent means that it's illegal, it's uncertain, and it's unreal. So for that economic value which is exchanged between the parties, for that it's necessary to be physically possible, it should be legal, and it should be certain, and it should be real, right? So that was about the consideration. We had 6 essentials for a consideration: desire of promiser, promisee or other person, acts abstinent or promise, past, present, and future, not necessarily adequate, real, and competent. So the example of present and future could be that on the spot you purchase something, you pay a value. So for you, something that you have purchased is a present consideration. For the other party, the value that you pay is a present consideration. Future consideration is usually, it exists in executory contracts, the contracts which are going to be performed in the future. For example, I promise someone to pay, or for example, I receive a value against something from a person, and I promise that that thing will be delivered to him in the future. For example, I want to import certain furniture from a company in Turkey. So first I pay, for example, full amount, and they promise to me that my furniture will be delivered in, for example, in 1 month. So for them, the payment that I made is a present consideration, but for me, the furniture that they deliver to me will in the future is a future consideration, right? Now let's talk about the capacity of parties. Capacity of parties is basically the second lecture of chapter number 4, and inshallah we will cover this topic as well in this 7th lecture, in 7th video lecture. So capacity of parties. Capacity of parties, what does it mean here? Capacity of parties here, parties means the contractual parties, people or individuals, or maybe natural or legal, who has an intention to enter into an agreement or contract or a business deal. Those are called parties. Capacity here means characteristics. What characteristics should they have or should they fulfill before entering into a business agreement, a business deal, a contract? So here by capacity we mean 3 things: age of majority, sound mind, and no disqualification by law. In Pashto we say aqil baligh, and कि मुजरिम ना बाशा, कि मुजरिम नहीं, आक़िलम भी, बालिग़म भी, और कम जुर्म हम नहीं. इधर कानून तरफ पे कम दोसिया नहीं, कम बंदिश पे नहीं लगे दले, आगा तमंगा competent parties वायु. Any person who is minor means who has not attained the age of majority, which is 18 or 21 years old. Any person who is unsound mind, insane, any person who is disqualified by law is not competent to enter into the agreement. So the person who is at the age of majority, he is major, he is a person of sound mind, and he is not disqualified by law from contracting, that party is called competent contract. The contracting party must be competent to the contract. Every person is competent to the contract who is of the age of majority, has sound mind, and is not disqualified from contracting by the law. A minor person, minor means a person whose age is less than 18 years, right? Or a person of unsound mind. Unsound mind is a person who cannot make rational judgment, he cannot decide rationally. His mind does not work properly. That's why he is a person of unsound mind. He is incompetent. A person disqualified by law from entering into a contract is also incompetent. Such 3 kind of people or parties cannot make an agreement or cannot enter into a deal or business agreements or in contracts. So now let's talk about the minor. Who is minor? A person who has not reached to 18 years of age is called minor, right? So minor is not allowed to enter into a contract. Per the Majority Act 1875, a minor will attain the age of majority after 21 years. Like there are two laws for becoming major. One law says that you should at least be of 21 years old. The other law says that you should be at least of 18 years old. So the more is better. Like if a person is of 21 years old, he can make more rational judgments as compared to a person who is 15 years old or who is less than 18 years old. So no matter if you are 18 years minimum or 21 years, you are allowed to enter into a contract because you are not minor, you are major. So major is a competent person, minor is not a competent person, right? So if you want to be more careful, so you do not enter into a contract with a person who is not reached to 21 years old, age of 21 years. Or if there is a person who is 18 years of age and he can make rational judgments, even that is okay. You can enter into a contract with such parties, but you have to be very careful. If you want to be more careful, you should at least the party who is at least 18 years old, you should enter into a contract with them to be more careful, right? And if someone is of 18 years old, you can also enter into a contract with them, but you have to he has to prove with paper, I mean his ID card, and that the authenticity of that ID card is also very important. There should be a documental proof which proves that he is 21 years old or 18 years old. You have to be careful for such matters while entering into a contract. Okay, nature of minors agreements. What happens if you enter into a contract with a minor, a person who is not the age of 18 years old or the age of 21 years? What will happen? What is the nature of the agreement? The first is that it's some void agreement. It's not the correct agreement, right? Means you are liable to perform, but the minor is not liable to perform. So when he has no liability, you cannot demand anything from the minor. If he denies to agree, if he denies to perform the contract, you will be liable for all the losses, right? He is not liable for compensation of the losses that you bear. Therefore, you have to be careful while entering into an agreement with a minor. An agreement with minor is void. A minor is not liable to perform any act which he has promised, because he does not possess the capacity to judge what is good or what is bad for him. Therefore, you are liable. He is not liable. When such cases go to the court, usually they reject such cases, and the person who is major and has entered into an agreement with minor, so the major is liable for all the losses, and there is no liability and compensation on the part of minor. So that's how it goes, and we have to be careful while entering into an agreement with the minors. Minor and ratification. Ratification means act of confirming or approving. By law, a minor is not allowed to confirm or accept an agreement after the age of majority. After he reaches to the age of majority, it means that a party now at the time of contract has not attained the age of majority, which is 18 years old, but he says that we will enter into an agreement now, and later on when I reach to the age of majority, I will reconfirm. Law does not accept this, so we have to be careful. Law says that when a person enters into an agreement, at the time of contract he must have attained the age of majority, which is at least 18 years old, right? Later on, the confirmation is not accepted by the law. Minor and estoppel. Estoppel, there is a rule in the law which is called the rule of estoppel. So the rule of estoppel does not apply to a minor, right? And it means that a minor is not stopped from insisting his infancy in order to avoid a contract, even if he has entered into an agreement by falsely representing. Estoppel means, what is the rule of estoppel? The rule of estoppel says that when you cannot claim to prove yourself to be right, that's called rule of estoppel. This rule of estoppel does not apply to minor. Minor can anytime prove himself to be an infant, right? Means that he is not stopped by the law to prove prove himself to be right. He always can prove himself infant, and he can always prove himself he is right and the other party is wrong or guilty. So that's why we have to be very careful. Minor has a free hand always. He can prove himself right, and he can prove you guilty at any time that he wants. So therefore we have to be very careful. Even though if he has by falsely representing the documents and all these things, he has proved himself to be major, but it's your duty to review those documents correctly and see if those documents are not false or incorrect or unauthentic, right? So that responsibility is at your part. Therefore the rule of estoppel does not apply to minor. Minor can always prove himself to be infants. Infant means masoom, right? And they can prove himself to be not guilty, and they will prove you to be guilty. Minor in repayment. There is no repayment. Minor can never be compelled to repay. So whatever you have paid to a minor based on an agreement that you had or a contract that you had with him, so he is not liable to repay. If he denies to perform, you cannot get what you have paid by the law, because it's your mistake that you have entered into a contract. Minor has no responsibility. A minor cannot be compelled to repay the money received by him under an agreement. If anything is recoverable from minor out of the proceeds of the contract made by fraudulently showing that he was a full age, the court may compel. The court will see, but most of the times minor cannot be compelled to repay, right? That's why we have to be careful. Minor and necessaries. A person who supplies necessaries to minor or anyone whom the minor is bound to support can recover a reasonable value of such goods from the property of minor. If minor owns no property, the supplier cannot recover the price of necessaries asserted. Sometimes a minor is supported by another person, by a major. So what is now the question is, can that major recover his value or whatever he has spent on the minor to educate him, to train him, to make him become a good person, or a person who is capable of a person with skills and education. So law says yes, the person who has spent on minor in order to support him, for example food, shelter, and education, and also dressing. If the major has spent on these 3 or 4 things to support minor, so the major has the right to recover only the adequate value, the correct value of all those spendings, not over value. Means the major cannot charge him more than whatever he has spent. So only whatever has been spent on minor can be recovered, but from his property, right? Or when he starts earning, then you can recover from him whatever you have spent on him, right? So in this case, the agreement of minor is not necessary here. Minor, after becoming major, cannot deny this and say that I have not accepted this with you, right? Law has given the right to the major to recover all the price or of all the necessities which has been spent on the minor. Next is agreement on behalf of minor. A contract made on behalf of minor by his guardian is binding on the minor. For example, if the guardian has entered into a contract on behalf of the minor, in such cases minors are required to perform by the law. It can be enforced against the minor provided the contract is written by the authority of the guardian and for the benefit of the minor. There are 2 conditions now. One is the contract is written by the authority of guardian and for the benefit of minor. Then there is like minor is binding. Then if the guardian has entered into agreement with another party on behalf of minor, but there is no benefit for minor or to minor, such cases minor is not binding, right? Minor is binding only if the contract is for the sole benefit of minor. Then the minor is binding by the terms and conditions of that contract, and this is by law. Minor as a beneficiary. Minor is capable of accepting benefits. If there is a contract where there is no responsibility of minor, in such cases minor can enter into such agreements because there is no responsibility on minor. Minor can enter into a contract as a beneficiary anytime, all the times, and the contract is valid. Minor is agent. Minor can also be an agent. Agent is a representative of a major, of another person. Since by law all the responsibility of a contract goes on the shoulders of the principal, or we can say on the first party, therefore the representative, who is called agent, there is no responsibility on his shoulders. That's why, based on no responsibility on the minor, a minor can enter into an agreement as an agent, and the contract is valid and correct. A minor can act as an agent. If minor works as an agent, he can make his principal responsible to third party for his act, but he cannot be held personally liable for negligence or breach of duty. For example, a company selects a minor as a representative, so this minor, who is the representative of a company, can enter into a contract with any party, because by law this agent has no responsibility against anyone. Even though he has signed the contracts, the responsibility goes to the company. So in such cases where minor is an agent, the contracts are valid. He can enter into a contract where he is an agent, right? So there were 8 types of agreements where minor was one party. So we know that basically in a contract where there is a minor, the contract is void. There is no ratification by the minor. Rule of estoppel does not apply. There is no repayment by the minor. We can spend on minor and we can recover the value for the necessities there is possibility of agreement on behalf of minor, and minor can enter into a contract as a beneficiary and also as an agent, right? Now let's talk about a person of unsound mind. Who is the person of unsound mind? So anyone who at the time of contract cannot make rational judgment or rational decision making, such person is called a person of unsound mind. It's necessary for a person to be of sound mind at the time of contract, not before, not later. If before a person was insane, but at the time of contract the person is of sound mind, can make rational judgment and decision, the person is okay and the contract is valid. Later on, if he becomes insane or becomes of unsound mind, that's not a problem, right? So at the time of contract, it's must that both of the parties should be of sound mind. Sometimes what happens is that in such big dealings, the contractual parties may do something to other party based on which he cannot make rational judgment, and he take the benefit of that, and he compels him enter into a contract which is of total loss for him. So such contracts are not accepted by the law. Such contracts are not valid. The contract is not valid. None of the party is bound to perform, right? A person is said to be of sound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interests. So, in simple words, we can say that a person needs to be of sound mind. Sound mind means he should be able to make rational judgment and decisions at the time of contract. It's very important, right? So, a person who can make rational judgment and rational decision making at the time of contract, he is a person of sound mind. He is okay to enter into a contract. Disqualified. There are certain people who are disqualified by law from entering into a contract. Mean such people. There are 5 categories: 1, 2, 3, 4, 5. These 5 people cannot enter into agreement by law. Number 1, joint stock company cannot enter a contract outside the powers given to the company by its memorandum of association. Every company is given a chartered by the law, so that company can only do business without those boundaries which are allowed by the law. Outside the boundary, the companies cannot do business. So if the company who was not allowed to enter into a certain act, and the company wants to enter to an agreement which is out of its boundaries and given powers, in such cases this company is disqualified. We should not enter into the company. So while entering into the joint stock company, into the agreement with joint stock company, we should check the memorandum of association and see if this company is allowed to do the business that we want, right? If by law they have the right or power to enter into such agreements, then it's okay. If not, then they are disqualified. We should not enter into the agreement with such companies. Diplomatic agent is not allowed to enter into any kind of agreements with anybody. Diplomatic agents are the representatives of a country who are sent on a diplomatic mission to the foreign countries. So all the diplomats who work in other countries representing his country, they are not allowed to do business in that country. Aligned enemy, the citizens of a country. Aligned enemy is basically an enemy of country. Like there are 2 countries and those countries are enemy to one another. So the citizens of those countries cannot enter into an agreement with one another. An aligned enemy whose country is at peace with the country is an aligned friend. A country with an aligned friend is valid. Contract with an aligned friend is valid. An aligned whose country is at war with your country is an aligned enemy. For example, there are two countries, they have war with one another, so the citizens of one country are aligned enemy to the citizens of other countries, so they cannot do business unless they have a clear instruction from the authorities. For example, Pakistan and India, they are aligned enemies. Pakistan and Israel, they are aligned enemies. In simple words, we can say that the countries who does not have their consulates or embassies in each other, those can be called aligned enemies. So the citizens of those countries cannot do business each other. Insolvent is basically someone who has bankrupt, who has nothing left to with the help of which who can contract. So an insolvent person cannot enter into a contract with anyone regarding his property which is in the control of official. Okay, so for example, I have a property, but due to my debts the property has been controlled by the bank, so I am insolvent now. I have nothing left. So by showing that this is my property, I cannot enter into the agreement with the other party, though I have the paperwork which shows the ownership, my ownership in that property. But since the control of that property is in somebody else's hand, that's why I am insolvent. I am not allowed to enter into the agreement, because there is more possibility that I will harm the other party as well. Convict is also a disqualified person. A convict is a person who has been imprisoned by a court of law. During the period of sentence, he is incapable of entering into a contract. If someone has a issue going on in the court and he has been sentenced or imprisoned, during the time of his imprisonment or during the time that his case is not clear, he is not allowed to enter into the agreements and contracts. So that's all about the capacity of parties. In today's lecture, we had discussion on consideration and the capacity of parties. Hope you guys have learned and understood whatever has been explained. If you have any questions, any comments, any recommendation, please do let us know. I am looking forward to hearing back from you. Thank you so much. Bye.